seeks permission from the bench to approach the dais. The counsel seeks permission from the bench to address the bench collectively as your lordships. Your kind lordship. The counsel is appearing on behalf of the appellant in the instant case of Dr. Shalini Vinayak versus State of Uttarakhand. The appellant was convicted under Section 304A IPC, read with Section 90 IPC, Section 337 IPC, and her license to practice medicine was suspended by the impugned order of the learned trial court. The counsel seeks permission from the bench to state the issues involved in the case.
Yes, you may.
Much obliged. So there are 4 issues in the case, Lordship. The first issue is whether or not the appeal is maintainable in a court of law. The second issue is whether or not the act of Dr. Shalini Vinayak amounts to negligence on her part. The third issue is whether or not the constitution and decision of the hospital administration is in accordance with the law. Then the fourth issue is whether or not the trial court has erred in finding Dr. Shalini Vinayak guilty of medical negligence under Section 304A of IPC. Wherein I shall be dealing with the issue number 1 and 2 and will take time of approximately 15 minutes, and my co-counsel shall be dealing with the issue number 3 and 4 and he will also take time of approximately 15 minutes. Now the counsel seeks permission from the bench to state the facts in the case.
Yes, please.
Much of this, Lordship. So, the brief facts of the case are: Dr. Shalini Vinayak, a 35-year-old geneticist who worked in New Life Hospital, was a passionate, dedicated, punctual medical professional towards her patient and her medical work. Mrs. Devanshi Rosli, herein the deceased, 42-year-old, was a patient of New Life Hospital, Dehradun, from the past 12 years. She was suffering from a rare life-threatening syndrome called ROHAT, which stands for rapid onset obesity with hypothalamic dysregulation, hypoventilation, and autonomic dysregulation. The family of the deceased appointed Polity, an 18-year-old caretaker for her. After spending 12 years in hospital, she gave up the hope of being cured, which resulted in avoiding medications and several times overdoses alcoholic tonics by her even after strict warning from the doctors. Dr. Shalini, here in the appellant, found a project named Discover Relief. Under this project, she found out that Elixir Lab, company which was manufacturing Mrs. Rothke's medicine of heart disease, has claimed that the drug they were marketing for Huntington disease has also cured a considerable percentage with expected percentage rate of success of 70%. The appellant informed about all the odds of the treatment to Mrs. Rothke, and Mrs. Rothke, the deceased, consented to the treatment. Though the appellant and Mr. Yashraj Mishra, MD of the Elixir Lab, were never fond of each other, as Mr. Mishra was a money-oriented person. Still, she wrote a detailed application on 25th March 2022 in order to ask for the drug for which Mrs. Rothke, but her application got rejected by Mr. Mishra, stating that the drug has not been approved by Food and Drug Administration. Dr. Shalini, here in the appellant, found out that Elixir Lab didn't want to introduce the cure of Rohat disease as it would reduce the company's profit. Dr. Shalini got the sample drug for Huntington disease. Dr. Shalini, here in the appellant, got the verbal consent from Mrs. Rothke in front of Polity to give her the dose of the drug, and within a week, Mrs. Rothke, the deceased, showed miraculous recovery, and on 1st May she was declared fully cured and got discharged on the next day. On 5th May 2022, the deceased contacted the appellant to thank her, and on 7th May, her news of demise came. The post-mortem report of the deceased confirmed that she died of cardiopulmonary arrest, and the case was registered as a case of sudden unexplained death. The husband of the deceased sued the hospital under Section 304A. which led to an investigation within the hospital to find the cause of the death. On 15 May 2022, hospital administration held a meeting consisting of 7 jury members, 6 senior doctors and Mr. Mishra regarding the action of Dr. Shah. Dr. Shani pleaded not guilty as she acted in good faith after receiving the consent of the patient, which was corroborated by evidence. After the hearing, 5 members, including Mr. Mishra, voted against Dr. Shani, the appellant, and consequently she lost her reputed job at the hospital. MCI also suspended her license for 7 years, and she was convicted by the trial court under Section 304 IPC, right with Section 90 and Section 307 of IPC. The council seeks permission from the bench to state the jurisdiction.
Yes.
Much obliged. The appellant in the instant case has approached the Honorable High Court to initiate the present appeal under Article 226 of Constitution of India and Section 482 of CRPC. The appellant most humbly submits to the jurisdiction of the Honorable Court. The council seeks permission from the bench to start with the arguments advanced in the first issue. Much obliged. So the issue number 1 is whether or not the appeal is maintainable in a court of law. It is most humbly submitted before the Honorable Bench of High Court that this appeal is maintainable in this Honorable High Court as per Section 482 of CRPC and Article 226 of Constitution of India. With due permission, I would like to quote the Article 226 of Constitution of India. Clause 2. Article 226 of Constitution of India. Power of High Court to issue certain writs. Notwithstanding anything in Article 32 of Constitution, every High Court shall have power throughout the territory in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories, directions or orders, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them for the enforcement of any of the rights enforced by Part 3rd and for any other purposes. In the case of Dilip S. Dhamkar versus Kotak Mahindra Company Limited, the Honorable Supreme Court.
Counsel, what is the citation of this case?
When the citation is Criminal Appeal Number 3355/2006.
So is
It is being highlighted in the.
decided by the Supreme Court or the High Court?
It was decided by the Supreme Court.
You have to mention the courts first.
The Supreme Court said, the Honorable Supreme Court said that an offender who has been convicted has the unalienable right to exercise the right of appeal. In light of Article 21's broad definition, the ability to appeal against conviction that has an impact on one's freedom is likewise a basic right. Therefore, the right of appeal cannot be limited in any or subjected to any condition. The right to appeal is guaranteed by Article 21 of the Constitution of India. So, here the phrase in the Article 226, for any other purpose, in the Honorable High Court has wide-ranging discretionary power, which also includes the power to hear appeals arising from the decision given by the learned trial courts. And with due permission, I would like to quote Section 482 of CRPC.
What question?
Section 482 of CRPC says, saving of inherent power of High Court. Nothing in this code shall be deemed to limit or affect the inherent power of the High Court to make such orders as may be necessary to give effect to any order under this code, or to prevent abuse of the process of any code, or otherwise to secure the ends of justice. Hence, in the light of the statutory provisions and case law cited, the appeal is maintainable before the Honorable Bench of High Court. Now, with due permission, the Council would like to proceed with the second issue in the case. Much obliged, Lordship. So, the second issue is whether or not the act of Dr. Shalini Vinayak, wherein the appellant, amounts to negligence on her part. It is most humbly submitted before this Honorable Bench of High Court that the act of appellant does not amount to negligence on her part as she acted in good faith for the benefit of the deceased, as Rohat disease was
So
life-threatening.
counsel, what are the parameters of good faith? How do you say that she acted in a good faith?
Much obliged with your question, Rakshit. The answer is, in section 52 of IPC, it is written that nothing is said to be done or believed in good faith which is done or believed without due care and attention.
Mr. Counsel, what is purpose of 452 CRPC?
Lordship, the main purpose of the CRPC as written in the code is that the main purpose is to secure the ends of justice. I would like to say.
So why 482 and 226? Maybe is there any alternate remedy? You could have filed a second appeal in any other court, which is having the jurisdiction to challenge the decision of the trial court.
Much obliged with your question, Lordship. The answer is yes, there is an appeal, but when there is question of law, I believe that honorable high courts and supreme courts are the best one to interpret the law. Here is the question of law of medical negligence. That's why we filed the appeal to the honorable high court.
So question of law, is it defined in any legislation that okay, this is a medical negligence and this is a question of law which is in question, as you are saying, and then it can be reverted only under 226 within the jurisdiction of the High Court and maybe with the Supreme Court?
It may be in the case laws of Supreme Court, but I beg your pardon, we do not have that case law.
Is there any other remedy in session court regarding this situation or not?
Yes, Lordship, there is
In which section?
section 374 of CRPC. Much obliged, Lordship. So, issue number 2, whether or not the act of Dr. Shalini Vinayak amount of negligence, I was in that issue. Section 52 of IPC I quoted. Now, in the landmark case of Jacob Matthew versus State of Punjab, Supreme Court, Criminal Appeal number 144 to 145 of 2004. The Supreme Court said, a simple lack of care, an error of judgment, or an accident is not proof of negligence on the part of a medical professional. A professional may be held for negligence on one of the two findings. Either he was not possessed of the requisite skill which he professed, or he didn't exercise with competence the skill which he possessed. Your kind Lordship, in our case, Dr. Shalini was a geneticist and she was also very reputed person. So we can say that she had the requisite skill to treat the disease, and hence her act of treating Mrs. Rodgi here in the disease cannot be regarded as negligence on his part. The Supreme Court formulated the concept of informed consent, in which when the medical professional has fully informed the patient of the risk involved in the medical procedure and subsequently the patient has consented to the procedure, then the medical professional cannot be held liable for negligence.
So counsel, you mean to say that if you are given your consent, that means you are ready to cause any infliction of any harm?
No, I didn't mean that, Your kind Lordship.
So
But-
do you have any authority other than apart from this V.P. Shanka's case? Because this is a judgment of 1995 and this maybe a new
Lordship, this
authority
case
on-
was also quoted in the Jacob Matthew versus State of Punjab.
This will be only for delayed one month.
Lordship, I would like to continue my with the arguments. Lordship, in our case, Dr. Shalini has disclosed all the facts and the risk and harm involved in the treatment, including the fatality percentage of 30% to the treatment to the disease. Moreover, Lordship, there was contributory negligence from the part of the disease. How? there was negligence on part of the disease as she started avoiding medication even after strict warning by doctor and several times overdose consisting of alcoholic content. This can be the cause for death because as the post-mortem report suggested, the death was of cardiopulmonary arrest and the death was registered as sudden and unexplained death. Lordship, we have a research paper about the cardiopulmonary arrest. Lordship, the research paper is from National Human Blood. It is basically of our American research paper. And if you will look at the second page of that, you will see the cause of the cardiopulmonary arrest is one of the causes that overdosing alcoholic tonics.
Does it mention in the facts that okay there was an overdose of alcohol and
Yes, Lordship, of course, it was mentioned in the fact, in the proposition also.
which para of the facts?
Lordship. Ma'am, Lordship, para number 4 of our statement of fact.
Mention the dose and quantity with
Lordship, it was not mentioned in the preposition of the facts, quantity of the dose. But there is written in the preposition that several times overdosing alcoholic tonics. So in the light of the statutory provisions stated, facts stated, case law cited, the act of Dr. Shalini Naik here in the appellant does not amount to negligence on the top. Thank you very much. Your kind Lordship, I have completed my part of the case. Now I would like to call my co-counsel upon the dais to deal with the rest part of the case with your due permission.
So this function from best to approach the next. So,